Good afternoon, Your Honors, and may it please the Court, my name is Jeff Beauchesne, and I am counsel for Ms. Dara Davis, the plaintiff in this case. We are here today for you to reverse and remand the findings of the Industrial Commission, in that Ms. Dara Davis's injuries did in fact arise out of her employment with the Raleigh Rage. We intend to show in principle that Ms. Davis's injuries arose out of her employment with the Raleigh Rage because of three key reasons. First, when Ms. Dara Davis performed a flip on the trampoline at the Holiday Health Happening event, she gave an appreciable benefit to her employer, the Raleigh Rage, because of Mr. Winborn's goals to secure a business deal with HealthCares, specifically for the $43 million worth of naming rights of their new stadium. Second, we would claim that the personal benefit that Ms. Dara Davis gained by attending the HHH event and speaking with the chief executive of the physical therapy department, Ms. Maria Chavez, was immaterial to the compensability of her claim because of the appreciable benefit that she conferred upon the Raleigh Rage to begin with. Finally, we would suggest that Ms. Dara Davis was impliedly required to attend the HHH event, and that despite meeting the number of public events that she had to attend for the year, her attendance was insisted upon by Mr. Bob Winborn, the team owner of the Raleigh Rage. Your Honors, if I could offer you a brief fact scenario of the case and why we're here today.
Counsel, did Winborn insist that Dara Davis attend this event, or did he encourage them to attend without actually ever requesting that they attend and merely provide diamonds to anyone who did attend?
Your Honor, my client's position is that she was in fact insisted upon attending because of the fact, first, that she was offered a pair of diamond earrings for her attendance, and also because Mr. Winborn stressed just how important the event was because of the potential of $43 million in profits due to the naming rights for the new stadium. I will again reiterate
So, Counsel,
that.
would you concede that it was not an actual insistence upon Winborn, but a mere implied insistence through the promise of diamonds?
Very much so, Your Honor. In fact, as I said before, it was impliedly required that she be in attendance that day.
Well, not required, but impliedly assisted.
That may also be a fair interpretation. Based on the case that I would like to present to you in my third point today, I hope to show you that that line maybe is less clear than you may believe, Your Honor.
Well, why don't you show us now?
Okay. To my third point of my argument here today, Your Honors, in Rice v. Uehari Boy Scout Council, the North Carolina Supreme Court decided that the claimant, who was a Scout executive on a Scout Executives Conference, attended a recreational fishing trip. At this fishing trip, he was injured by a part of the anchor that came loose on the boat. Ultimately, his claim was compensable because the court found that he was in fact impliedly required to be in attendance that day because the chief executive expressed that it was practically compulsory that he be there or that all executives be there unless he was ill. Ultimately, Your Honors, we feel that this case is analogous to Ms. Davis's claim because of the diamond earrings that were offered, as well as the fact that Mr. Winborn had stressed just how important the deal was to the Raleigh Rage.
Now, Counsel, don't you think there's a difference between stressing how important something is and pretty much mandating that you go on a Boy Scout trip?
I would agree, Your Honor. I would struggle to say that the claimant in Rice was in fact mandated to go. It was explicitly stated in the case that this was a voluntary event, while the court recognized the benefits also to the employer that the Scout executive gained by attending the event. It was not, in fact, specifically required of his employment. Which brings me to my first point that the court outlined as well in Rice, of an appreciable benefit that was conferred upon the Raleigh Rage by Ms. Dara Davis. This court set up in Roman v. Sutherland Transportation the appreciable benefit test for that purpose. An accident which occurs while an employee is offering aid to a third party, which reasonably tends to retain the employer's business and to promote consummation of specific new business, arises out of the employment. Specifically, Your Honors, I would like to talk about Lewis v. Kentucky Central Life Insurance. In this case, the insurance agent, who is the claimant in the case, went to a policyholder's house the night before he saw her on the side of the road the next day. At her house the night before, he also spoke with a family member of the policyholder who intended to take out a new claim. When he saw Mrs. Moorhead, who was the policyholder, on the side of the road the next day, he decided to give her assistance. When he got out of his car and gave her assistance, he was struck by another car. The court held in that case, Your Honors, that that the insurance agent was reflected in a positive light because of his assistance to Mrs. Moorhead, and that positive light reflected in the possibility of new business because of the solicited business of the new policyholders that he had spoken to earlier that night. We find this case to be analogous to Ms. Davis's claim here because she too used that same practice of goodwill to speak with Ms. Chavez and agree to Ms. Chavez's requests of getting on the trampoline and making sure that the Holiday Health Happenings event went on more smoothly.
So does Ms. Davis did she have any part in actually helping coordinate how they were going to raise these $43 million or get the $43 million from Healthcare Inc. for the Rage?
Other than within her role as a cheerleader and employee for the Raleigh Rage, was expressed to her by Mr. Winborn, specifically within the negotiations of that potential contract, no. But our point here today is that the goodwill that that the insurance agent established in Lewis is akin to the goodwill that Ms. Davis established by appeasing Ms. Chavez.
But counsel, doesn't Roberts and Roman hold that mere speculation of goodwill to the employer is not enough to satisfy the appreciable benefit test?
It does, Your Honor, but really the key is if the ultimate effect is to suggest that there is new business. And while it is unfair to speculate...
What's the case law that asserts that key?
Your Honor, again, I believe it's Roman, as I stated earlier, Your Honor, in the appreciable benefit test, aid to a third party which reasonably tends to consummate specific new business. So I would argue, Your Honor, that Ms. Davis's actions did in fact reasonably tend, in this case, and in the nature of the Workmen's Compensation Act, which is to be liberally construed in favor of the claimant, did in fact confer an appreciable benefit.
Counsel, is that Roman at the appellate level or Roman at the Supreme Court level?
That is at the Court of Appeals, Your Honor.
Well, my assertion from Roman is actually at the Supreme Court level that mere speculation of goodwill is not considered an appreciable benefit, so how would you reconcile that?
Again, Your Honor, I would look then to Lewis v. Kentucky Central Life and say that in the same way that the policyholders respected and admired the agent, they respected and admired the insurance company. Thus, in the same way that they respected and admired Ms. Davis, they respected, that being healthcare's, respected and admired Mr. Winborn and the Raleigh Rage. I see my time is coming to a close. If I may conclude, Ms. Davis appreciably benefited the Raleigh Rage by creating goodwill between Ms. Chavez and herself. That goodwill held the potential to bolster a business deal between healthcare's and the Rage. Secondly, the fact that Ms. Davis sought a personal benefit was immaterial to the compensability of her claim because she did in fact confer an appreciable benefit to the Raleigh Rage. Finally, Ms. Davis was impliedly required to be in attendance that day due to the insistent request of Mr. Bob Winborn. It is for these three reasons that we ask here today for you to reverse. I see my time is. I see my
Go ahead and
time
finish.
is-
Go ahead and finish.
Thank you. It is for these three reasons that we ask that this court reverse and remand the decision of the Industrial Commission for further consideration that Ms. Davis's injuries did in fact arise out of her employment. Thank you.